Yes.
I'm going to pick it up now in June 2000 with a note, a submission from Lord Hunt to the Secretary of State. It's DHSC 5297720. So we can see here from Philip Hunt, that's Lord Hunt, is it?
That's correct, yeah.
To Alan Milburn, who was then the Secretary of State for Health. Is it right to understand from your witness statement that you drafted this for Lord Hunt to send to
Yes.
Mr. Milburn?
Yes. I recognise the style.
And it's in the context of seeking his agreement for a strategy for settling the A and others HCV litigation.
Correct.
And the reason I'm taking you to it now is in relation to 2 and the second bullet point there. Settling the litigation has significant presentational difficulties, given that we are refusing financial assistance to haemophiliacs infected with HCV through blood products prior to 1985. Can we go over to page 3, please? Just to pick up a couple of points there, at paragraph 9 at the bottom. My concern, however, has been around the terms of such a settlement. I want to ensure that there is a clear and defendable distinction between settlement of this litigation and our continued refusal to compensate haemophiliacs infected with HCV through blood products on the basis of non-negligent harm. Can you recall what the concern was about there having to be a defendable distinction?
Give me a moment just to reflect back on that.
Well, perhaps I can ask the question in a different way. One of the concerns that the department had, or one of the lines to take that the department had used as a reason for not having a compensation scheme, was that they didn't pay out for non-negligent harm, effectively.
Yes.
And here we have this litigation, which is making a payment for non-negligent harm.
On a different basis under the Consumer Protection Act, so on the basis of it being a faulty product, essentially.
And was there a concern then that was an inroad into that line that the department was taking?
I think it was probably more of a concern presentationally that we have one group receiving a settlement through the court, and what does that say for everyone else who is looking for compensation?
And then it goes on at paragraph 10. The main plank of our argument for refusing payments to haemophiliacs has been that heat treatment to eliminate HCV from blood products was introduced as soon as the technology was available. This is not true for the introduction of the screening test for HCV, and a financial settlement can be justified on that basis. And I just wanted to ask you about that. Is it right to understand from this, from what we've just looked at, that the internal position of the department is that HCV testing could have been introduced sooner? Or was that just your view, or indeed Lord Hunt's view?
I think that would have been my understanding, and it would have been based on a view from within the department generally.
Do you think that that is at odds with the public position and the lines to take that we've been discussing this morning about the fact that there was no wrongdoing and that matters were done as quickly as possible?
I think it's the distinction that's being discussed here between the inactivation of plasma blood-based products and the introduction of a screening test for labile blood products.
Would this, going back to the discussion we had this morning about what could have triggered a review of the policy on whether or not to have an inquiry, is this precisely this, that the department view was that screening for HCV hadn't been introduced as quickly as possible? Would that not have been something that could have, or even should have, triggered a public inquiry?
Don't honestly think I can speculate on that. It was not something that was discussed at the time as a weakness to the stance on not having an inquiry.
Can we then go...
Just before we do that, if we can just go back for a moment to your paragraph 9, which is in front of you on the screen. You raise an issue as to the difference that there might be between those who sued as claimants in the litigation and those others who suffered from exactly the same problem, having contracted HCV as a result of blood products. Given that the litigation was essentially in respect of a defective product, if the claimants were to succeed, presumably that would be on the basis that the product was indeed defective.
Yes.
And that must apply to everyone who had received it. At the time, at least, it was held to be defective.
Yes, although the settlement would only apply to those who were
Precisely.
parties to the group action.
So what you were looking for was what Lord Hunt was looking for was a distinction between settling a case and others, and you I think were concerned that there might not be any logical distinction between the position in which the two groups were. Both had suffered the results of having a defective product.
I think we were clear still about a distinction between between clotting factors, which should be heat treated as soon as it was possible to do that, and virally inactivated for HCV. And so that's the argument that everything was done as soon as it could possibly be done, and blood for transfusion, which was the subject of the litigation. So yes, I think there was a question. Okay, let's sit down. Is what are the implications of this judgment more widely?
Yes.
And that was the issue that we were concerned with.
Yes. Thank you.
So if we then turn to matters in July 2001, could we have DHSC 004-1379_177? And here we have a submission to Yvette Cooper from Bryony Enser, haemophiliacs infected with hepatitis C by blood products, and it says, as requested, to provide a position paper on the above in the light of the recent High Court judgment which awards damages to people infected with hepatitis C through NHS blood transfusion, and to outline the options for action. So the purpose of this is to re-look at the position as a result of the conclusion of the hepatitis C litigation. Is that right?
Yes, I mean, we did see this as an opportunity to review the issue, and Bryony joined my team on a temporary basis just to do this.
And picking up on the point that you were just discussing a moment ago, if we go to the bottom of this page, the last bullet point before timing, Although this judgment only places a legal obligation on government to make payments to those awarded damages by the courts, it introduces further questions of inequity and increases the moral pressure to do so. So is it right to understand that that's one of the drivers for re-looking at this question of compensation?
Yes, I think that the whole question, if one group is compensated, why not everyone?
And then if we go, please, to page 4, the options set out there. There are 5 main options for action. Do nothing. This, like all the options, entails compliance with the letter of the CPA judgment, that's the hepatitis C judgment,
Yeah.
and the legal precedent that it sets. 2, public inquiry, lump sum and hardship fund for all haemophiliacs infected with hep C by blood. 3, lump sum and hardship fund for all haemophiliacs infected with hep C by blood and low-key inquiry. 4, lump sum and hardship fund for all or some haemophiliacs infected with hep C by blood. 5, hardship fund for haemophiliacs infected with hep C by blood and who have severe liver disease. And then it refers to an attached options paper, which we will look at in a minute. Mm-hmm. And then the advice is, at 18, if ministers wish to consider making payments to haemophiliacs with hepatitis C, option 5 is recommended, and the reasons are set out. It re-establishes the government's stance on no-fault compensation, provides an equitable outcome for haemophiliacs in a way that the judgment does not, effectively diffuses the campaign on behalf of all haemophiliacs by targeting only those as sick as the victims of HIV and AIDS, and entails relatively modest costs. And then it talks about the impact on the devolved administrations, and ministers needing to be asked for a decision before the recess. So the advice on this document, at least, is somewhat equivocal. It's not saying we're putting forward option 5. It's saying if you want to do something...
It's a toe in the water, really.
If you want to do something,
yes,
we would suggest option 5. If we can just then turn to the options paper, DHSC 002 0756 _025. And we can see there it's headed hepatitis C options for haemophiliacs infected with hepatitis C through blood products in the wake of the CPA judgment. And then if we turn over to page 2, we can see how it's set out. So option 1, compliance with the letter of the CPA judgment and the legal precedents that it sets, the do nothing option, and then it sets out the for and the against, and then it has a comment at the bottom. So I wanted just to draw your attention to what's said about option 5, which is at page 5. Mm-hmm. Again, we've got the same outlay there, the options set out, then the for and against, and it's the bit at the bottom that I wanted to draw your attention to. It talks about the government being able to recover the high ground, and then that second sentence. This is an easier line to hold than continuing to exclude those dead and dying from hepatitis C infection in blood, and then sets out what the McFarlane Trust already administers, that hardship fund. So is this, in a sense, the rationale for choosing option 5, that it's more logical and it's an easier line to hold?
And less costly than some of the other options. Yes, so it's a cautious, I think it is probably deliberately cautious given ministers' previous view on compensation, but it is providing ministers with an opportunity to say, yeah, let's do this.
And it's going to Yvette Cooper, not to the Secretary of State, even though he would ultimately be the decision maker, given what you've told us this morning. Because she asked for it, she's interested in it.
And she's the minister at this stage responsible for this particular issue, so it would go to her first. It would then get accelerated up the ministerial line, as it did do later on to John Hutton
and
as the Minister of State.
Indeed, we'll come to that. So then, if we can then turn to the paper that you've referenced several times this morning, which is your submission to Yvette Cooper of the 19th of July, which is at DHSC 6983_129. And here we can see it's from you, 19th of July, to PSPH, haemophiliacs with hepatitis C, and then you say you've asked for a response to 3 questions.
And this would have been in response to Bryony's submission.
Indeed. So Bryony's submission's gone to Yvette Cooper. She's asked 3 questions, and you're responding to those 3 questions. What would have happened if the no-fault compensation scheme had been put in place at the time of the judgment is the first question. Second question, by giving haemophiliacs money, what other groups would then want compensation? And the floodgates point. And then if we turn over the page, please, to page 3. If we were to make some sort of symbolic gesture, what could that be? What would a money package look like? What kind of sums are we talking? And if we look at paragraph 8, you set out, well, first of all, you set out the principles in paragraph 7. It needs to be affordable and it needs to be acceptable to the Haemophilia Society. And then at paragraph 8, you say a package which we can be fairly confident the Haemophilia Society will find acceptable is at Annex A. And we'll have a look at that in a minute, and that is going to cost 37 million, with the bulk falling in year 1. And then you talk about being able to reduce that to 20 million if you restrict payments to those with cirrhosis and end-stage liver disease and those who have already died. And then at paragraph 9, you look at a cheaper package in the short term, no cash payments, but a hardship fund run by the Macfarlane Trust to make monthly payments to haemophiliacs with HCV who are at the advanced stage of illness. And then at paragraph 10, you make the point that if additionally payments are made to non-haemophiliacs, this would push the cost up considerably. And then if we turn to Annex A, which sets out the scheme, we go to WITN 4505025. We can see that you set out at the top half of that page the numbers that you're talking about and those you've got from the UK HCDO. And then if we look at the bottom half, you set out what the possible package is. And you say one-off cash payments on a rising scale depending on the stage of illness reached, worked out in detail, but could look something like antibody positive 5,000, PCR positive 10,000, fibrosis 15,000, cirrhosis 25,000, end-stage liver disease 40,000, payment in respect of those who have already died 40,000. And then you say the sums suggested are illustrative and are at a lower rate than damages awarded in the recent High Court action, which ranged from around 10,000 for antibody-positive patients to £60,000 for a patient with cirrhosis. So, first of all, how did you? I mean, you've caveated those figures, saying that very much would need to be worked out in detail and are illustrative. But how did you come to those figures?
I don't recall, in all honesty. I mean, it refers to this being based on the Canadian scheme. So it's possible that I looked at the amounts awarded in Canada and came up with an equivalent. But I don't recall exactly, I'm afraid.
And having done your best to work out the numbers and cost out the package, that went back to Yvette Cooper. And I think you've said that was then escalated to John Hutton. Is that right?
That's right, yes. I mean, the thing I thought was an important message to a point made to Yvette Cooper as well in the submission is the point about the question she raised about would this open the floodgates to others, and I said yes, but there could still be an argument for making an exception for people with hepatitis C.
We can look at that if. So if we look back, if we go to back to DHSC 306983_129. So we've got the that question at the bottom of the first page about the floodgates. If we turn over the page, you set out your thinking on that, and it's, I think, at paragraph 6.
Yes,
you
that's
say,
right.
Despite the existence of these groups, it would be possible to justify payments to haemophiliacs as exceptional, given that hepatitis C-related illness, which can lead to cirrhosis and liver cancer, is a devastating, debilitating disease. Around 200 haemophiliacs have died as a result of this infection, and at least as many, again, are likely to die in future. So was this a shift in emphasis in terms of advice to ministers then?
This is me trying to push it. I think giving ministers an argument that they could use if they really wanted to go for a scheme.
We know from your witness statement that this was escalated to John Hutton, and he was against a compensation scheme. Is that right?
That's correct.
And do you know why that was?
I don't know.
I just wanted to pick up one more point on this document that we've got in front of us, and it's in paragraph 3. And you talk there about the numbers of the scheme, and you say this: these numbers may be manageable within any scheme. And you're talking there about the numbers of the numbers in the group, 669 patients that have been identified from a look-back exercise conducted by the blood service, 113 of whom had received damages through the High Court, leaving 556 patients uncompensated. And you say this: these numbers may be manageable within any scheme. More worryingly, is estimated that there are between 4,000 to 5,000 other patients still living who were infected with HCV through blood transfusion who cannot be traced. These people may or may not know that they are infected, and a proportion of them could well come forward if a compensation scheme is announced. It's likely that the existence of a scheme would encourage people who have had a blood transfusion to seek an HCV test. For the vast majority, there will be no documentary evidence to prove that blood transfusion was the cause of their infection. However, we would probably be obliged, if we had a scheme, to award damages on the basis of probable cause. Now, leaving aside for a moment the point about documentary evidence and a scheme awarded on the basis of probable cause, I want to come and ask you a question about that in relation to another document. Was any consideration given at this stage to trying to trace those 4,000 to 5,000 patients who you thought were infected with HCV but couldn't be traced?
No, I don't believe so. And of course, that was still an issue at the point the Caxton Foundation was set up.
And do you know why that was the case? Why thought wasn't given to it at that stage to try and find them and to give them treatment?
I don't. I don't know how easy it would have been to trace people. So there may have been obstacles there.
Now, you've noted in your statement that matters in Scotland were taking rather a different course to that in England, and that the Scottish Parliament's Health Committee had published a report in October 2001 calling on the Scottish Executive to implement financial support for those infected with HCV via blood and blood products. And for the transcript, that is WITN 4505027, and then that the an expert group, often referred to as the Ross Committee, had been instructed to make recommendations for compensation, and its preliminary report had been published in July 2002. And again, for the transcript, that's DHSC 0042275_132. So who was your point of contact in Scotland for receiving updates and for being kept up to date about what was going on in the developments there?
I'm trying to remember his name. I mention him a lot in my...
Mr. Stock.
Mr. Stock, Bob Stock, that's it.
And what was the relationship between Scotland and England like? Were you kept up to date adequately?
Yes, I think there are various points through my evidence where it shows us in touch with Scotland, and we tried to ensure that we kept each other informed so there were no surprises on either side.
And did you, on behalf of the department, express concerns to Mr. Stock or indeed to other colleagues in Scotland about the direction that Scotland was going?
Are you referring to anything specific here?
No, it's a general question. I'm talking about the hepatitis C payment scheme, but
until the issue of the Scotland's powers under devolution came up, raised by Mr. Milburn, no, I don't believe I did.
Given the direction that Scotland was going in, was there any consideration given in England to England, any thought given to whether England should follow Scotland?
I think on compensation, the thought was that Scotland should follow England.
We'll come then to the point you've just referred to, Mr. Milburn raising the question of whether or not the compensation scheme was a devolved matter. And can we do that by reference to the chronology that you created? And that we can find at WITN 4505035, and it starts at page 7. So your witness statement tells us that this is a chronology created by you. What was the purpose of creating this chronology? Can you recall?
I was just trying to remember. It might have been for, I don't know what, it may have been for a briefing for Hazel Blears, possibly. To be honest, I just don't recall what prompted me to do this. I was quite keen on chronologies, just as a way of seeing the sequence of events, but yeah, I don't honestly recall why I produced this one.
And then if we go to if we go please over to page 8 and pick up on the last entry there, 4th of November, Malcolm Chisholm phones SOS to inform him that, and if we go over the page, the expert group were about to publish a preliminary report calling for financial and other practical support for all people infected with HCV through blood products and tissues. Scottish ministers felt they had to offer something, probably payments to people once they became seriously ill, and that an announcement would be made on 6th of November. SOS said that he thought this would be a grave mistake and that once the principles that we'd established had been breached, then we were on a slippery slope to payments running into the millions across the UK. He said he thought Malcolm Chisholm needed to tough it out. Malcolm Chisholm said that the advice he had was that this was a devolved matter for the Scots. However, he wasn't sure that this was right. SOS subsequently asked officials to find some way of showing that the Scots don't have the devolved power to go it alone on this, and thereby prevent them from going ahead with any kind of announcement on 6th November. Now, can I ask whether or not you were present during this telephone conversation?
No, I was not.
So how was that reported to you?
It would have been reported to me by Alan Milburn's private secretary.
And then that last paragraph there that I've just read out, the Secretary of State subsequently asking officials to find some way of showing that the Scots don't have the devolved power. Was that a request made to you?
It was.
And so we can see the submission that you drafted at WITN 4505036. So did you understand the purpose of or what you've been asked to do effectively was to go away and find a way of showing that the Scottish did not have, if there was a way of showing that the Scottish were not able to have their own scheme, go it alone effectively?
Yeah, or at least to be clear what the devolved powers were in this case, and given that Malcolm Chisholm himself had doubts about what the devolved powers were, it was, in that sense, a useful thing to do to establish that position.
And so we can see here that this is a submission from you to the Secretary of State, 5th of November 2002. And the background is set out at paragraph 2, the developments in Scotland, and that paragraph 4, the concerns that the Scottish Cabinet have to establish that any difficulties associated with disregarding payments for social security purposes can be overcome, and also that the UK government agrees that the establishment of a scheme to make ex gratia payments of this nature falls within devolved powers, and the steps that Malcolm Chisholm will be taking to address those points with Andrew Smith. And then if we go over the page, you say this under the devolution issue, paragraph 7, health is devolved with one or two exceptions that don't help us. However, social security is not devolved. Our lawyers have suggested that a scheme which makes payments to people incapacitated or suffering hardship through illness is arguably a social security, not a health scheme. Therefore, we could run the argument that the establishment of such a scheme does not fall within Scotland's devolved powers. And then you go on to talk about the social security scheme reservations. And at paragraph 9, you say this, at the bottom of paragraph 9, as this is not about the legal liabilities of the health service, no such liabilities exist, there would seem to be a strong case for arguing that the principal purpose of a payment scheme is to relieve financial hardship and is therefore not health related. And then paragraph 10, Sols have stressed that this is not definitive advice and that if SOS wants to use it, I think it must be, yeah, it would be best not to go into too much detail at this stage. However, we could certainly say that we also have doubts about whether such a scheme is within Scotland's devolved powers, that given this and the considerable implications of such a scheme for the rest of the UK, that Malcolm Chisholm should not go public until these issues have been resolved. Our lawyers could then take this issue up with their opposite numbers in DWP. So, again, looks like the beginning of that submission, you're suggesting that the arguments are pretty equivocal, but then you say at one point, well, there's a strong argument, and then at the end, the solicitors seem to be saying, well, not definitive advice, best not to go into too much detail at this stage. Was the aim to try and put the brakes on the Scottish from announcing the scheme in order to give time to try and persuade them out of it, or in order to give time for the department to consider the implications for themselves?
I think it was to try to maintain an agreed UK-wide position The concern being that if the Scots made this announcement, as the Secretary of State had commented earlier, we would no longer have an agreed UK position. So the attempt really was to sort of go back to having an agreed position, whatever that was. And it's interesting that paragraph 11 here as well, with the Office of the Deputy Prime Minister's comment.
Which bit?
I think where I said ODPM.
This is more of a so ODPM. See this is that what you say? See this as more of a political issue, one that can be resolved through legal arguments. So was it, in a sense, trying to buy some time in order for the political issue to be worked through?
Yes, I think it was going back to Malcolm Chisholm and saying, we agree with you, we're not sure that you do have the devolved powers to this, so please don't rush into an announcement. Let's look into this in more detail, try to resolve it, either resolve it legally or resolve it through political discussion.
And what is it? Is it your view that the most significant issue in moving England towards a hepatitis C compensation scheme were the developments in Scotland?
I think so, yes. I think it moved things on in a way that nothing else had.
I want to return to the issue that I said I would in relation to the documentary proof of people being infected with hepatitis C in the submission that we looked at to Yvette Cooper. But I want to do it with reference to a different document which says makes a similar point, and it's DHSC 304601_021. Now, this is a submission from you dated the 12th of November 2001 to MSH. Is that Mr. Hutton?
That would be Mr. Hutton, yes.
People infected with hepatitis C through blood and blood products. And then you set out the purpose of the submission. When we met in September to discuss the campaign to compensate haemophiliacs with hepatitis C, you took the view that compensation for this group was not appropriate, but asked us to investigate ex gratia payments for people infected with hepatitis C through blood after the introduction of the Consumer Protection Act, who on the basis of the High Court judgment would have received damages had they gone to court. These people are now caught by a time bar, preventing them taking their own legal action under the CPA, and a care package for haemophiliacs with hepatitis C on the lines of the one devolved for people with people with CJD. But it's really what's written on over the page on page 2, and this is under the size and the cost of the scheme that I want to ask you about, and it's the top paragraph there, the bit in brackets at the end. So you're talking there about the total cost of the scheme, total cost of a scheme, and you say this: although there is unlikely to be any direct evidence linking these individuals' hepatitis C infection with blood, there are precedents for schemes which award payment if the person has not been exposed to other known risks factors, e.g. injecting drug use. So we've seen in 2 documents you making this point that are unlikely to be direct evidence linking individuals' hepatitis C infection with their treatment. What was the factual basis upon which you'd arrived at that conclusion?
I honestly don't recall. I mean, it would have been based on discussion with possibly with the UKHCDO or with other experts. But at this distance in time, I honestly can't recall what that was.
And are you there referring to the fact that it was your understanding that there would be gaps in medical records for whatever reason, so that people wouldn't be able to prove that they'd had a blood transfusion, for example?
Yes, I think that was the assumption that, yes, yeah, I would say so.
And while I don't want to make too much of this, because you're clearly not being asked to devise a scheme and the procedure for a scheme, but in both of the documents we've seen you expressing a view about this, you have made the point that factor would need to be taken into account in the design of the scheme. So, for example, here you're saying, well, you know, there are precedents for schemes for saying, you know, if you haven't been exposed to any other risk factors, you would meet the test.
Yes. Yeah, I mean, recognising there would need to be some kind of test, whatever it was.
But a test that would take into account the fact that you would expect to find medical records not being terribly helpful to prove the link between the transfusion and the hepatitis C.
Yes. Yes, indeed.
Now, you left the department in May 2003, and the scheme Skipton Fund wasn't announced until August 2003. Had there been discussions about by the time you left the department about there being a scheme and what it might look like?
No. There had been nothing since the proposals that had gone to Yvette Cooper and then to John Hutton, which have some similarity, I think, with how the Skipton Fund turned out, but there'd been no further discussion.
And were there any discussions after the memo we looked at where the devolution point was raised? Were there any discussions between the department and Scotland about setting up a national scheme, or any further discussions with Scotland about what was going to happen?
There were not. As I recall, the devolution issue went to the law officers for a decision, and that decision had not been reached at the point I left.
So, just reflecting back on the approach taken to the compensation scheme during your time at the Blood Policy Unit, was there to your mind, a serious exploration of alternative options, i.e. a real look at reviewing the policy of no compensation?
Other than the exploration of the issue with Yvette Cooper and with John Hutton, no, that was the only occasion where we went back to ministers and said, this is what you could do. I mean, we did that, I certainly did that, in the hope that ministers would decide that they wanted to come up with a scheme, and I think we pushed it cautiously at first and then a little more firmly. But after the decision that no, there wouldn't be a compensation scheme, certainly in my time there was no further discussion about it.
And so you've described that as a toe in the water to begin with, but is it right to understand then that having done that, it was your view that it was for ministers to pick up and run with it? And having not got that, there was nothing further you could do? I
think the submission I wrote to Yvette Cooper with a possible scheme and an argument for justifying that scheme against the argument that it would open the floodgates, for example, was quite a sort of a firm. It was giving ministers a real opportunity to do something.
You've reflected in both your second and third statements on whether or not there was a collective mindset or a group think in the department about issues such as public inquiry, the HCV compensation scheme. What do you mean by a collective mindset or a group think?
I think in situations where a decision is taken, you develop a set of lines to take. Those lines to take get used again and again. Nobody particularly questions them. A debate happens in the Commons and we use the same lines to take. There is a risk that you don't question, you stop questioning that. I think as well, you know, from everything I heard from the point of joining the blood team to when I left was the view that everything was done as soon as it could be done. That was something that everyone believed. I didn't challenge it. So that's what I mean as well, that there's that risk that if enough people believe something, it becomes quite difficult to say, actually, maybe that's not the case, maybe we should look at this differently. I'm not saying that happened, but I think there is always that risk.
So do you think that decision-making in the department on both of these issues that we've been looking at this morning, the HCV payment scheme and the public inquiry, were affected by groupthink or the collective mindset?
I think the point I make in my second witness statement when I refer to this is that looking back on this, I asked myself whether I could have, done anything differently, and I said I wasn't honestly sure that I could have done, and I think that's where I am still at. That although we might have all felt that we were right about this, that there wasn't a case to answer, that there wasn't a case for compensation, that there wasn't a case for a public inquiry. I'm not sure that I was in a position, as a middle-ranking civil servant with views taken by many more senior people and by ministers to challenge that, even if it had occurred to me to do that.
I'm going to ask you some questions now about your role as liaison with the Alliance House organisations. And of course, at the time that you were in post at the Blood Policy Unit, there were just two of them. There was the McFarlane Trust and the Eiling Trust. Is that right?
That's right, yes.
What was your role as head of liaison with the McFarlane Trust and the Eiling Trust?
There were two key roles. One was about ensuring that they received the funding they need to continue operating, and the other was on the appointment of trustees. The trustees, which according to the trustee were to be appointed by the Secretary of State. But there was also a general an accountability relationship, if you like, with the Department of Health as the sole funder. There were regular discussions with the Alliance House about their needs, the ongoing needs and changing needs of their beneficiaries and how those should best be met.
In your statement, you describe the two charities as being operationally independent of government, and as you've just said, the nature of the relationship being an accountability relationship, and you've described it as being light touch. Is that really right when the Department of Health is the sole funder, and so is able to have a significant say on all matters of reserve policies, for example, operating balances, whether or not particular policies, payments should be made for particular beneficiaries and so on.
Our main concern was around good governance, essentially. We wanted to ensure that we established a budget for the trust to work to and that they operated within that budget. And the story, if you like, is towards us establishing a framework where they were in receipt of regular capital top-up funding from the department within an agreed budget, with a system that allowed them to put the case for increases on the basis of the needs of beneficiaries. It started off as a somewhat ad hoc system, and what we wanted to do was to get it into a place where there was both certainty for the trusts and certainty for the department.
So is this right in terms of the process by which the McFarlane Trust got top-up funding from the department, that they had a reserve, and when it got close to 4 million, or dipping below 4 million, that was the point at which they knew that they could come to the department and say, we need a top-up of our funds?
Yes.
And what was the reason for the reserve being so high?
I mean, that was something that was set before my time, and the trust, as they continue to do, put that reserve into investments and gained income from that. I think it was to give, essentially it gave the trust a high level of security. I mean, there was never any suggestion or possibility that the department would stop funding the trust, but that security was there for them.
And is this right, that the process by which the trust would make applications for funding was, as you said, ad hoc, but also, in a sense, informal, that it was simply a question of writing a letter and saying, can we have some more money?
Yes, it was. And the difficulty was that quite often we would end up having to have a sort of end-of-year negotiation with DH Finance to say, can you find 2 million or whatever it was for us to give to the McFarlane Trust out of end-of-year underspend, which is not a very satisfactory way of funding any organisation.
And the reason for that is because the McFarlane Trust were coming to you effectively. The Department of Health is setting its budgets and financial allocations in advance, and the Department of Health the McFarlane Trust is coming to you after that process has been undertaken.
Yes.
And saying, can we have it now, please?
Yes, and also without any real discussion about if they needed additional money, about why that was, with no business case supporting it.
And when you say a business case, what do you mean by that?
By that I mean, and this did get better. Something that says, we have a group of beneficiaries who are now expected to live longer, who are marrying, who are going to have children, so the needs of those beneficiaries are changing, and therefore the type of support we want to give is changing, and that's going to require more funding.
So, in effect, a properly worked up plan about how much need there was in the beneficiary community, how the trust proposed to meet that need, and what it would cost and why it would cost that much, and then what that would cost the department in terms of funding.
Yes.
Is that what you're talking about?
Exactly. And we had certainly we had some discussions about whether, for example, the trust might be considering providing funds for things that would otherwise be provided by the social security system or by local authorities, and therefore was this the best use of the money that the department was providing. We certainly had those kind of discussions as well. But where we ended up is that I put a bid into the 2002 spending review. So for the first time, there was a budget allocated through the spending review process for the McFarlane Trust 3 years ahead. So they knew exactly what their income was going to be over those 3 years and could work to that with an agreement that for the next spending review round, we would look at their case for what future funding should be.
And so that budget that was set in advance was based not on a proper business case, but on an estimate of what they said they needed. It
was based on what they felt they needed, and was, I mean, at the start of this, the figures are in the my witness statement, and forgive me if I don't remember them exactly, but we were providing roughly 2 million a year, and we moved that up to 3 million a year. So in a very short space of time, it was a 50% increase on what they had been spending.
And how do you think a proper business case would have been received by the department during your tenure? If it was to ask for an increase in funds, how do you think that would have been received during that period?
Well, we did provide an increase in funds, and beyond, I mean, the next opportunity to do that would have been the following spending review, which was after my time, and I'm not sure what happened at that point. But I think the point is that they did make a case quite clearly, both to us and to ministers, for additional funds based on the needs of beneficiaries, the kind of needs that I described earlier. And we did provide that. So we went from roughly 2 million a year up to just over 3.
And would a request for increased funds with a worked up business case have made it more likely that that additional funds would be granted as a matter of generality?
I think it depends. I mean, once we'd established the funding through the spending review, there wasn't then an opportunity to add anything to that until the next opportunity for the spending review. So I think.
But at the point that the budget was being set, yes, at the spending review.
Yes, I mean the department would have listened to it. Whether it would have agreed, I don't know. I mean, it would have depended on what was being asked for.
And why, presumably.
Yeah, indeed.
You were asked by the inquiry when you were writing your witness statement about what the and I'm paraphrasing, so I may get the question slightly wrong, but about what the department's view would have been if trustees had campaigned or lobbied for a change in government policy, or a question of that nature. And you say in your witness statement that there was nothing to stop them from doing so, but you don't recall an instance of when trustees did do that when you were head of blood policy. In February and March last year, when the inquiry was hearing evidence from trustees of the McFarlane, certainly the McFarlane and Eileen Trust, what was said by one, possibly more of them, was that their view was that if they had engaged in such campaigning or lobbying, there was a risk that the department would have withdrawn funding. Now, obviously that's their view, but is there anything that you could assist us with in understanding how they could have come to that view? Or
I don't know. In my view, there is no conceivable circumstance under which the department would have withdrawn funding from the McFarlane Trust. The trust was set up by the department to provide support for beneficiaries through the trust, and there's no way we would have pulled the plug on that.
Do you think that if, in terms of what was put to some of these witnesses was, well, look, why didn't you make the case publicly for more funds? They were saying that the trust was, in their view, underfunded. Why didn't you make the case publicly for more funds? And the response was concern about department withdrawing funds. Do you think the department would have been responsive to a case made publicly for more funds? Would that have been an effective way of trying to get more money out of the department?
I'm not sure it would have been necessarily more effective. It certainly would have put pressure, perhaps, on ministers, but in the same way that ministers resisted calls for compensation over many years, despite very effective campaigning by the Haemophilia Society and others. They could, I guess, this is speculation, but they could have similarly resisted campaigns by the Macfarlane Trust.
I'm going to turn then to issues about trustee nominations from the Department of Health.
Well, just before we do that, I wonder if I may ask something. When the evidence was given to me by those who were engaged in running the Macfarlane Trust in particular, and Peter Stevens was particularly strong on this, the fear was that the department would withdraw funding. Now, you're saying, well, there's never was any possibility of that, which is a diametrically opposed view. Are you aware of any statement made in Parliament or any letter written by any minister to the Trust to state to them, you needn't worry, we'll go on funding you for however long it takes, or words to that effect?
I am not. I mean, certainly at the point we provided funding through the 2002 spending review for the Macfarlane Trust, there was that assurance of a 3-year funding.
At that stage?
At that stage.
And that's, what, 14 years
Yes.
in, roughly?
Yes. And normally once you go into the spending review cycle, these things renew. So although there's never any guarantee, it gave, I think at that point, the Macfarlane Trust a good deal more certainty than they'd had previously. And that came along with some very positive messages, I think, that Hazel Blears gave to the Macfarlane Trust around the same time. So I can only speak for the time when I was working on blood policy, but at that point in time, I think the Macfarlane Trust were, given a good deal of clarity about ministers' ongoing support and the certainty of that 3-year funding.
Now, in the course of that answer, you said that it gave them a good deal more certainty about, if you like, their future funding, which might suggest that your view of what they had felt in the past might not entirely have been unjustified.
I don't think so. By certainty, I simply meant that we'd moved away from the ad hoc style of funding we'd discussed earlier, where the trust would come to us and say, we need an extra 2 million next year. And we'd go away and find it. We always went away and found it, and sometimes a little more than they'd asked for. But it was done in that sort of ad hoc end-of-year underspend way that didn't feel satisfactory to me and was 1 year at a time.
Yes.
So there was never an occasion where, I think always they had no reason to believe that if they asked for money, we wouldn't find it, because we did. But what we were able to do later on was to say, well, you've not only got funding for next year, but you've got funding clearly set out for the next 3.
Yes.
And that will hopefully then go on to a rolling cycle.
Yes, thank you.
So you mentioned at the beginning of me asking you questions about your role in relation to the Alliance Health organisations, that one of the key matters that you were concerned with was the appointment of trustees. And is it right to understand then that the Department of Health was responsible for nominating some of the trustees for the Macfarlane Trust and all of the trustees for the Eileen Trust?
Yes. Now, for the Macfarlane Trust, some trustees were nominated by Department of Health, some by the Haemophilia Society. I'm trying to remember what the Eileen Trust situation was. I think what normally happened is that Macfarlane Trust trustees would then sit on the Eileen Trust, or some of them would sit on the Eileen Trust as well. And to be honest, I don't recall whether those were also the Department of Health nominees.
Now, during your time at the Blood Policy Unit, and we see this reflected in your witness statement, the Macfarlane Trust wanted the Department of Health to nominate retired civil servants as the Department of Health appointed trustees for the Macfarlane Trust. Is that right?
That's correct. Both Peter Stevens, when he became chair, and Anne Hithersley as chief executive, were very keen on that.
I think there's also reference to Peter Stevens' predecessor having the same view as well.
Yes, Alan Tanner. Yes, I believe he did. Yes.
Why did you understand that to be the case?
Why did they value
Yes.
ex-civil servants? Peter Stevens set that out for me, and it's mentioned in my witness statement. It was at the point where Yvette Cooper questioned it as well. And from recollection, Peter's argument was that ex-civil servants knew how the system worked, knew how to make difficult decisions, often with limited or competing evidence, and knew how to make a case for funding to ministers. I think those were the kind of things that he was looking for. So it was that expertise that the Trust found valuable.
And for the transcript, the documents that you've just referred to are Yvette Cooper's views are set out in an email, WITN 450-5330. Peter Stevens' response to you is set out at WITN 450-5331. And as a result of Yvette Cooper's concerns, is this right, you sought some advice from Nigel Crisp about the appointments process?
That's right. I mean, that was because because the Trust wanted retired civil servants, we advertised the role through the Cabinet Office list of retired civil servants who were interested in public appointments. We didn't advertise it publicly because it was a very specific requirement. Yvette Cooper asked whether this was a case of the old boys network. And because the permanent secretary has, in a sense, the last word about proper process within government, and in this case, the Nolan principles around public appointment, we went to the permanent secretary to get a view about whether he thought that we had done enough to satisfy the Nolan principles in making these appointments.
And and his response was he was satisfied that you had. Is that right?
That's correct.
Do you now, looking back, consider that only advertising the vacancies to retired civil servants may have meant there was, or appeared to be at least, a lack of independence from the Department of Health?
I mean, that question came up around my own appointment later on to the Caxton Foundation, of course. My feeling is that when people were appointed as trustees, even if they were, former Department of Health, to begin with, their responsibility as trustees was to the charity. There was certainly no expectation on the department's part that they would somehow be Department of Health people within the charity. I certainly had no individual contact with them as trustees. My contact was through the chief executive and the chair. So there was nothing in the way that this was set up that would introduce any biases, as far as I can tell. Now, had we done this today, we would certainly have advertised, or even 5 years later, I suspect, we would have advertised these roles publicly. In those days, it was acceptable to say, we've got a pretty circumscribed role here, we know the group of people we'll want, so we'll just advertise it to that group of people. I don't think that would be acceptable now, certainly.
You've set out in some detail in your statement, and I don't want to go to it, but what you term as entirely avoidable and embarrassing delays in the allocation of Section 64 funding
Indeed.
to McFarland Trust. Section 64 funding being the funding that the trust needs to fund its operations, fund its
Yes, so we had a sort of
so
two funding streams, one to support the trust's work with beneficiaries, and then one for the admin, which was the Section 64, and that meant that there was clear separation between the two. And yes, as you say, there were some dreadful delays early on, well indeed, and later as well, for slightly different reasons, in awarding those Section 64 grants.
And was that as a result of what you were telling us this morning about the understaffing and the pressure of work in your unit?
I think so, but what I say in my statement is, looking at this now, it's so embarrassing because this was probably a couple of hours' work at some point, and we could have dealt with it so much more quickly, and avoided the irritation felt by the McFarland Trust and the embarrassment to us. So it was one of those avoidable things that should have been done much, much earlier, and because of everything else going on, wasn't. And it's the sort of thing I look at now and squirm over.
And does that tell us anything about where in the priority list, you were talking about having to prioritise the work, where in the priority list the Alliance Health organisations came for the unit?
I don't think so. It was a piece of paperwork that needed doing, and I think it was just a bit of bureaucracy that needed to be done, and we were focused on, if you like, sort of, we had regular meetings through that time with the McFarland Trust and the Eileen Trust discussing issues. I was constantly in touch with Anne Hithersay as the chief executive. We had an ongoing dialogue. So if you like, we were dealing with the big issues while neglecting something small and bureaucratic that could have been dealt with easily and would have saved some grief.
So I wonder if now would be an appropriate time for the lunch break.
Yes, it would. We'll come back at 2 o'clock. 2 o'clock.